today is an interview that is unique and I think will be very, very valuable for many people listening. We're getting into the legalities of influencer marketing. We're bringing on a close friend and someone who's an advertising attorney in Robert Freud. He's been a close contact for the Kinship team when it comes to any questions around legal advice or anything of that nature of how to go about it in the proper way. Of course, this can be a dry topic in terms of legalities, contracts, all these different things, but there's things like the FTC. There's things like what recently happened in the past couple months of Mr.Beast giveaway and what went wrong with that. There's things like usage rights, that there's a lot of brands that are using content that they can get caught, and what are the ramifications of that? And how do you go about it the right way? And what are the chances of actually getting caught? So I think this will be a very valuable episode. It's not the exciting, sexy topic, but it is a topic that everybody listening to our show needs to understand in a greater way. You cannot skip over the legalities. You can't just use and abuse these influencers, whether it be on just the relational side, but certainly on the legal side. This is becoming a very popular thing. Just even in the attorney world, there's advertising attorneys that are hawking at and looking at cases constantly, because as you'll find out in this episode, there's a lot that goes into it and there's a lot of money to be made on everyone's side. So if this is something that you're interested in, that you want to send to your team, you want to send to your CFO, you want to send to anybody that would get value out of this, if you're going to be investing in influence marketing, this is a topic that you need to understand well. And also, Robert is someone that you can start consuming his content to understand and even get in touch. He's in California, so he's restricted to that state. But nonetheless, I think this will be a valuable episode. Let's jump in. All right, we have a unique guest with us today. We're going to get into all things legal for those that are curious about that side of things when it comes to influencer marketing. This will be the podcast for you. I hope I didn't lose like all of our audience when I say everything legal, but very interesting guest, Robert. What's up, man?
Doing? Thanks for having me.
How do you pronounce your last name? Freund?
Yeah, that's right.
Nailed it. Do you actually remember how we met or how we all got introduced?
I think it's one of those things like either Instagram or Twitter, or maybe it was through the chat or...
Robert has been a close contact to the Kinship fam, providing advice, and was even part of our influencer marketing blueprint course, giving some helpful tips to people that have bought that. So, but anyways, I'll stop talking. I'll let you introduce yourself.
I'm Rob. I'm an advertising and e-commerce attorney. Basically, the majority of my clients are either direct-to-consumer brands or marketing agencies and some individual talent and creators. And essentially, if you make money selling things online, I help you keep it rather than forking it over to a regulator or a plaintiff's attorney or a competitor or something like that. I was in commercial litigation at a big law firm called Greenberg Traurig for the first 6.5 years of my career. Decided I did not want to stay in the big law life. Left in 2019 to start my own thing. And I focus now on avoiding litigation in the first place rather than actually litigating the cases. So I help with FTC compliance, complying with the various state consumer protection laws that apply to online businesses, and sort of general, like outside general counsel work too, whether it's setting up your business, drafting your vendor agreements, reviewing all your documents, things of that nature.
On my end, what kind of leads to that transition, or what first sparked your interest with transitioning to influencer marketing? Is it you're on social, something that interested you? Is it you just saw a niche just because not many people are in it? You just see this like entire market space that's kind of the wild, wild west. So there's just a massive need. Like what kind of led to that transition for you?
A lot of the cases that we were defending at my previous firm were false advertising class actions. And that subject matter was the most interesting to me of the cases that I litigated. I think advertising law is the most interesting area. Just personally, it's the kind of stuff that I'll read about on the weekend just because I'm interested and not because I have to for work. The psychology of marketing, how the legislature comes up with rules to try to rein it in and protect people or hurt businesses, depending on your point of view. And then how all that plays out in the courts and the tension between marketers and regulators and plaintiffs lawyers is the most interesting stuff to me. So when I left that firm, I knew that I wanted to focus on advertising law as a sort of broad area. And around 2019, around when I left, is when um, both of the Firefest documentaries came out, and I hadn't really done like that much of a deep dive on the issues around influencer marketing specifically, but I was watching those documentaries and they highlighted the FTC's involvement with respect to the influencers that were promoting Firefest but didn't disclose they were paid to promote it. And I thought, well, I need to be putting out content and writing articles about what I'm doing anyway to promote my new firm. Let me take a little deeper dive into the FTC rules around influencer marketing. Wrote an article about that, and then I didn't really like set out to have influencer marketing as a segment of my practice, but I got invited to do a speaking engagement at an influencer marketing conference. And then I realized there was a lot of work to be done, or at least people interested in understanding what the rules are so they can protect themselves. And it became more of a focus from there. And since I'm on social media and a lot of my client base is either working or already on social media, it's just a natural thing to discuss. And conveniently for me, unfortunately for a lot of businesses, the FTC has paid more and more attention even since then. And there's more issues to consider around influencer marketing as time goes on.
I love it, man. You gave the much better intro. If you sell anything online, I hope you keep your money. That's a fire statement right there. Well, anyone listening, I'll just go ahead and say it on behalf of Robert that any advice that Robert gives today is not actual legal advice. So I'm sure you're going to say that at some point yourself. You actually just posted something that I wanted to bring up real quick because I thought it was interesting around Mr.Beast and his giveaway that kind of went a little bit viral a couple days ago. I retweeted it on Twitter. Can you give like a little 30-second overview of people that maybe didn't come across that, what exactly he did wrong? Because Mr.Beast is like the top of the top in terms of an influencer, and he's even breaking some rules.
Yeah, so he did a promotion where he was going to give away a total of $50,000 in cash. And in order to enter, you had to share the story or share the post to your story and comment or something like that. And then he was going to pick a winner, which is fine to do. Like, there's nothing inherently unlawful about running a sweepstakes on social media. Brands and creators do it all the time. But there's considerations you need to be aware of. The platforms have their own rules about it. Instagram has a separate section of its terms of service dedicated to running contests or sweepstakes on the platform. And then there's federal and state laws. Every state has some law about what your official giveaway rules need to say, where they're presented.
Right.
In a couple states, you have to register in advance. It's not like rocket science stuff. It's not, you don't have to be a genius to understand what the rules are. But they're there and you should know what they are so that you avoid the risk. And I was a little surprised because Mr.Beast obviously is one of the most popular content creators in the world, but he had such obvious omissions in terms of complying with the terms of service, and there were no official rules. He had made one comment like, "Oh, New York's excluded," which can make sense to do, but it looked really sloppy. I made the thread to bring awareness to the fact that I'm not hating on Mr.Beast. Like, I don't feel strongly about him one way or another. I know a lot of people do, but using celebrity examples is a great way to get people to actually at least get on their radar that there are issues that you might want to take a look at if you're going to do something similar rather than just copying him. So that's what the thread was designed to do. It's like, hey, Instagram has these rules. Here's how it doesn't look like he's following them. And here are the state laws that apply too, and what you need to do if you want to do this the right way. And he's such a lightning rod for controversy that it went viral a bit, I think, because people will see a post that looks critical of Mr.Beast in any way and assume like I'm trying to ruin his life or something. And that's basically what happened in terms of people picking up on it.
All press is good press.
It's gotten a lot of attention. I felt I have people who didn't think I was going after him or trying to cancel it. At least a lot of people are thinking about sweepstakes and maybe if I'm going to do this, especially for my brand, whether or not you choose to comply to the letter of the law with everything you do in your advertising, you should at least know what those risks are, and then
Yeah.
it's a business call as to what you want to do with that.
Rob, let's get spicy here. Let the audience tune into the craziest case that you've worked on as it relates to influencer marketing.
I haven't litigated that many. My goal was to get out of litigation and work more on compliance stuff. But I see the same sorts of disputes come up over and over again. I probably pick better examples of cases that I've covered on social media that I've been actively involved in. But
The craziest one that you've read about and you can speak to.
I was just thinking the last case I litigated, it was less about influencer marketing and had more to do with an issue that comes up in influencer marketing all the time. And this is what I was going to mention anyway, is publicity rights. If you use somebody's name or image or likeness or their voice, if it's identifiable, without their permission, without something in writing that says, hey, you can use my likeness for this purpose, then you have a publicity rights violation on your hands. And those laws can be especially nasty if you're trying to defend against them for a number of reasons that I can get into. But the last case I had was a video game publisher had used a guy as like a model for a character you could play in a video game. They didn't use his name. He was designed to be the character that you pick who's not a famous person that you can customize. You can change his hair, height, everything you can customize about a character you could do. But he was the one person in the whole production that they didn't get a publicity rights release from. Once the game became popular, years later, he tried to file a lawsuit. Well, he did file a lawsuit about it. They eventually got that case dismissed. It was certainly more of a headache for their client than they would have liked to have had. And all of that could have been resolved much quicker with a publicity rights release from the person who ended up becoming litigious. But that sort of thing comes up all the time. There's a case I covered that's still ongoing right now, a common situation in influencer marketing. A brand will license one piece of content, like, hey, I really like this Instagram post you have. We'd like to use it. And can we repost it and we'll keep it up for 6 months or what have you, like a normal type of licensing agreement. And then whether by mistake, someone new on their team, or intentionally, they use either another piece of content from that creator that they didn't have the rights to, which is what happened in this case. This model agreed to have one of her images used for cosmetics brand on their socials for like a 6-month period. Later, she's in a Rite Aid and sees her face on the shelf on a product. And she's alleging, well, this exceeds the scope of what I agreed to. And now you're in, a national chain of retailers and you violated my publicity rights because of that. That kind of fact pattern comes up constantly. Like I probably have a weekly consultation on one side of that or another where that has happened. And it's oftentimes just a lack of clarity up front and making sure that the brand and the influencer, even if they had the same thing in mind, making sure that what they put in writing reflects that. So there isn't some confusion later. And if there is, you can very quickly say, look, this is what we agreed to.
Yep. Gotta have usage rights, people. I would imagine some people might be listening to this and they're like, okay, but what are actually the ramifications of all this? Like,
yeah,
maybe even people have used, influencer content that they're posted from, on Instagram. That was a lot of the thought back in the day. It was like, hey, they posted on social. It's public, so I have the rights to use it. They tag my brand. I'm just going to use it. Speak to that a little bit. Obviously, I know you can go like many different directions based on the size of the brand, based on the size of the lawsuit, but like, I guess warn people, for lack of a better word, on some of the ramifications of what could happen if you start messing with this.
Yeah, it might seem like, or it's a common misconception that if a brand misuses like one piece of content, that they're not going to find themselves in court. They're going to get an email or something from that creator, or maybe a cease and desist or something, and maybe they'll pay a few $100s, or they'll take it down, and that will make it okay. It's a mistake to think that. There's no requirement that somebody send you even a cease and desist before they file a lawsuit. And the reason the publicity rights piece, separate from a copyright issue, which we can talk about later, is so thorny is because in some states like California, the legislature understood when they wrote this law that it's going to be hard for someone, especially not a celebrity, to say they were harmed and or lost money to such an extent that they're going to want to go pay legal fees to try to make it right. So there are some laws that allow you to recover your attorney's fees if you prevail. And the idea is to make it equitable for somebody to hire a lawyer if they know that if they prevail, they'll get their fees back. That's not the default. Usually each side has to pay their own way through a lawsuit. The publicity rights statute is one of those that makes it much more appetizing for a lawyer to take that case, even if the damages are small or zero, because if they have a good claim, these are usually pretty simple. Like you either used that person's likeness or you didn't. There can be nuanced cases, but a lot of the times there's not much of a defense. And the longer you fight it, the bigger the plaintiff's bill is going to be that you're going to have to pay. In California, you don't even have to prove that you were harmed. You're entitled to a minimum of $750 per violation plus your attorney's fees. And at no point do you have to prove that you lost any money as a result of the use. So, for example, there's one of the more high profile cases was from a few years ago. There's a photograph of the actress Katherine Hagel leaving a Duane Reade pharmacy. Whoever's in charge of Duane Reade's social media took that photo and put it on, I think it was their Twitter. It might have been their Instagram. But just one picture of her and said, look who's leaving our store. And she sued, demanding $6 million. And they settled. We don't know for how much, but probably more than Duane Reade would have liked to have. There's a case pending right now. Selena Gomez is suing the developer of some mobile game. There's a picture from like the cover of some magazine. They used one picture of her. She is demanding $10 million. The case is ongoing. And it's like, those are celebrities. But even if you're not a celebrity, you can still end up with a significant exposure, even if you're just using one piece of already public content that identifies somebody.
So to recap, though, you're saying for like the actual publicity usage, you don't have to, at least in California, you don't have to say that like or prove that you're harmed. And then also what you're bringing up about attorney's fees, that it's not on the influencer or those who are like quote unquote wronged to pay those attorney fees, but it would be on the brand in this case.
The brand loses, they have to pay for their own lawyers.
And you're basically saying it's so cut and dry most of the time. It's like you either used it or you didn't, that there's not like nuance involved. So answering that question of like, what's the warning is that you're paying double the attorney fees and whatever the settlement is. And it's usually pretty black and white, whether you broke the law or not.
Yeah.
I have a one-off question on this. This is happening everywhere, right? I mean, especially with, nano influencers, micro influencers. You see it all the time. Brands just say sorry later, don't ask for permission, say sorry later, whatever it is. Based on all the things and the misconceptions that you already spoke to. Are there attorneys out there like looking at this as just a ripe marketplace just to come up on right now? And hey, I saw this UGC and this brand's advertising, just making sure that they have usage rights to it. If not, let's go get them. Like, are attorneys going and trying to find these opportunities instead of like these influencers seeking out that assistance?
Yeah, they absolutely are. And a lot of the times it's in conjunction with lawyers. It's even that kind of machinery is even better built out from the copyright perspective. So you have two potential issues, at least, if you're taking some content that you didn't clear the rights to. If someone's identifiable in it, you have that publicity rights component we've been talking about. But somebody has the copyright to that image if your brand didn't take it or didn't clear the rights to it. And whoever has that copyright, if they've registered it in time, can sue for copyright infringement and obtain up to $150,000 in certain circumstances per act of copying for work. And there are plaintiffs' law firms out there. Their entire business model is scour the internet for every violation of copyright and just spam out either demand letters or a lot of them won't even do that. You'll find out that you're being sued when you get served with a federal lawsuit. I have alerts set up for certain keywords that show me how frequently this kind of thing is happening. And there's one firm that just in the past week has filed 6 lawsuits against iHeartMedia because for like random blog posts where they'll take a picture of a house or something that they're talking about. or it's a blog post about real estate, and they're using just some image they found, who knows where on the internet, to discuss whatever they're discussing, and they're served with copyright infringement lawsuits, and that's because it's those lawyers' entire business model is essentially just spamming out those lawsuits, knowing that they'll settle for $5,000 to $15,000 per one of those filed. And if you can get 100 of those out in a month, that's not a bad living.
I would say this is becoming pretty common for people to think like that misconception. Once again, we'll just run it, roll the dice, nothing will probably happen. What percentage of people that are saying that and are doing that would you say actually do get caught? And just put it, a lot of our listeners are like brands around 5 million annual revenue to like 50 D2C startups. What percentage of those types of brands are getting caught?
It's really hard to say. I don't know that anybody has collected the data on percentage of potential violations versus what happens. And part of that is because federal lawsuits are pretty easy to access and keep tabs on. State courts are a little bit more difficult. It can be done, but the data is less immediately available in terms of how many of a certain type of lawsuit is filed. And we'll never know how many disputes are resolved before that lawsuit is filed, whether it's, settling through after a demand or something like that. So it's hard to totally get your arms around how often this happens. But I can tell you that especially the copyright issue, there's at least a handful of firms that are just pumping out those lawsuits pretty much literally all day long, kind of like the ADA website accessibility stuff, maybe not the same scope, but pretty close. And the publicity rights claims are common too. I have an alert set up for that California claim specifically, and there are 4 more that I was looking at filed just today for a brand using a picture they didn't have the rights to is the claim. So
you got to get a couple of these people on one brand. You get a couple class actions going. That's real money there.
Yeah, there are a few of those. They're like Classmates and those yearbook websites have suffered some losses over just like using the people in their directories in ads. There's several class actions against those sorts of sites. The defendants are having a tough time getting the claims dismissed. But there are other situations you could imagine where a publicity rights class action could work. But even if it's an individual claim, you're up against that attorney's fees leverage, and it's not a good situation. So, can you roll the dice and get away with it forever? Possibly. Some claims, it's more likely than others, but
it's really the wrong question too. I mean, I know the purpose of you being our guest is obviously the legalities, but it's just like the question of how much can I get away with this particular influencer is just completely ruining the relationship at scale. As soon as they find out, it's just like you're done. And now with these platforms like F You Pay Me and all these ones that are kind of glass door for influencers, like your brand is your Dunskies at the end of the day. So just want to throw that in there, but we'll keep going with the legal questions.
It's a good point. And just a follow-up question on this, let's just throw a hypothetical at you, Rob. Okay, we're the influencer marketing agency. We're also running paid social. We're doing this on behalf of a brand, our client. We work with this influencer, or we see this influencer post about this brand. We go collect their content. We don't talk to them. We don't get usage rights. We go run this with the brand's approval to go do it. Who's liable here? Are we getting sued out the yin yang? Is the brand getting sued out the yin yang? Who's liable? How does that dynamic work?
To be clear, we always get usage rights.
It depends a bit. So you're saying in this hypothetical, there's no contract with the influencer that discusses any of it.
They get an ad of themselves and they're like, what the heck?
3 parties involved: agency, brand, influencer.
Yeah, I mean, potentially both of you are. Most likely, the way that would play out is the influencer's probably not going to understand that the agency was involved in this, at least not at the beginning of the process. So they're probably going to sue the brand. If that agency had told the brand that, hey, whatever assets we give you or content we give to you is free to use, then the brand could bring the agency into that litigation and say, like, this was fraudulent, or you breached whatever contract we have or something like that. Maybe there's an indemnity clause that would get invoked, something along those lines. But from the influencer's perspective, both of you are potentially liable, and then it will be between you, meaning the brand and the agency, to sort out whose at fault is between you and who ultimately would foot whatever the result of that dispute is. You can't just sort of pass the buck back and forth between the brand and agency if that hypothetical played out.
You brought up earlier FTC. In layman terms, give people, like, I'm sure some people have heard of it, but like, what is the FTC? You put out content around FTC all the time. So what is that?
The Federal Trade Commission is the federal agency that is charged with enforcing what we commonly think of as false advertising laws and truth in advertising principles. So their rules apply across the country because they're a federal agency. So broadly speaking, they say that all advertising has to be truthful, not misleading, and substantiated. They have a number of rules and guidelines that apply to particular industries and segments of marketing, like online marketing in particular. And they have a set of rules that they call the endorsement guides that frame what they consider or what they would consider to be deceptive advertising in the context of influencer marketing. So what most people probably think of when they think of the FTC and influencer marketing, if they're thinking of this sort of thing, is hashtag ad and disclosures. And the general premise is that people should know when they're being advertised to. And if I see an endorsement or a review or a testimonial from somebody, it might affect the weight or the credibility that I give to that endorsement if I knew that they had a connection to the brand. What the FTC calls a material connection there that's not otherwise obvious. That connection has to be disclosed in that piece of content or where that advertising is. That's why we have hashtag ad and
Hashtag sponsored.
right. We can get into like how to disclose that. You don't need to use even a hashtag when you make a disclosure. You don't have to, like, ad is not your only option. Sponsor is not your only option, depending on the context. That's the idea. People need to know when they're advertised to, so the FTC has come up with rules and guidelines about how to achieve that.
Such an interesting world that we live in with social media. Because, I mean, obviously, it's like when you'd see a celebrity back in the day on a commercial, everybody knows that they're being advertised to by Lexus and George Foreman. You know, it's like now we have social media and you have something where it's like created out of friends interacting with friends, but now you have this influencer market and, well, I follow this person, I view them as a friend. And what you're exactly saying, they bought this product and they just want to share it with their audience, or is it actually they were paid to promote this? And that's why the FTC was essentially created, correct? Or in this market, I guess, specifically?
The endorsement guides in particular, the rules that relate to disclosures in online advertising, started with things like when blogging was more popular, things like advertorials, like if you're, a fashion blogger and a brand reaches out and says, hey, we'd love if you write about this product. That sort of predated what we think of as influencer marketing, even though it's really the same thing. Somebody with an organic following now has some piece of sponsored content that they're putting out, and the audience should know that because, like you said, unlike a TV spot where you know that's advertising and no one's going to be misled about that. The reason influencer marketing, or part of the reason it's so effective, is because it doesn't feel like advertising. And that's the tension between how do we protect the consumer from parting with their money under false pretenses or through some deception versus how do we make advertising effective, not feel so.
Question kind of just off the cuff. I feel like I've peppered you with these sort of questions in the past, Rob. I'll just paint a hypothetical scenario here. You talked about how in California, it's like $750 per asset. And it sounds like, Selena Gomez can sue for $10 million. We'll see if she gets it, whatever. They may settle at a bigger number. If it's a micro influencer or a UGC creator or a customer, someone that doesn't have a ton of clout, that's like you said, they're not going to be hurt by that if it's ran as an ad without their permission or without usage rights. What goes into the amount that ultimately they're able to sue for? Like, what goes into that calculation? Is it, hey, this brand spent $1 million behind that ad, even though that creator will never know how much money was spent behind that? Or do they have the right to know that? And does that go into the calculation of it being a bigger number? It was put in front of this many people. Hey, this brand only spent this amount of dollars. Not many people saw it. Does that go into it? Or does none of it go into it? Like, if you can elaborate on how that plays out, I think that'd be fascinating.
Yeah, all of that can go into it. Or sort of assuming that we're just talking about the publicity rights claim and not something else, like there could be false endorsement claims under the federal statute or the copyright claim that we were talking about. But all the things that you mentioned can go into that especially at the initial stage, evaluating what the case is worth. The starting point could be, if this is a content creator that has got brand deals in the past, what do they charge for something similar if they have? Like, using their own comps is a great starting point. But then, yes, you can also consider, how successful was this campaign? How widespread was it? How many ad dollars were behind it?
Does the creator have a right to know those numbers? If they ask those questions to a brand, does the brand have to say, yes, this amount of ad spend went behind the creative, this is how it performed?
So many purchases we got.
If we're in the context of litigation and you're past the initial stage of a case, so to try to summarize this as quickly as I possibly can, when you first file a lawsuit, you don't get discovery right away. Usually you don't get discovery right away. You can't just ask for whatever you want. The person being sued gets an opportunity to have the court kick the case out, essentially saying, look, even if everything they alleged is true, they can't sue for what they're suing for. They haven't met the elements of whatever that claim is. And so we should end the case. If that doesn't work, or there isn't that challenge, then discovery opens. In the context of a publicity rights claim, or the brand either chose not to try or couldn't dismiss it at that first stage, then the influencer would have the opportunity to say, we need records showing how much you spent in this, what it meant for your brand, how successful it was. Discovery is where a lot of the legal fees come in, because there's very commonly extended fights about it and going into court about who gets what and what has to be, confidential and protected and this and that. But the long story short, at a certain point of the case, yes, the influencer has the right to obtain that information.
Helpful. Well, Rob, we appreciate you jumping on. Where can people find you, and where's the best place to consume some of your content?
Instagram, and now Twitter, since people seem to react more sharply there than on Instagram. It's at Robert Freud Law for both of those. And you can always book a consultation through my website, robertfreundlaw.com. Yeah, that's pretty much where I am.
He's definitely always been our guy, our go-to guy for all things legal within this space. So comes with our highest recommendation.
Appreciate you coming on, Robert.
I appreciate the invite.
All right, that's all for today. If you'd like some help developing your influencer marketing campaign, go ahead and DM us on Twitter. Links are in the description. Or you can head to kinship.co to learn more, and you can book a call there. That's KYNSHIP.co. At kinship.co, you also find tools, templates, and resources, all designed to help you grow an influencer campaign that drives visibility and sales, not just likes. Thanks for tuning in as always, and we'll see you next week.